Hello students, and welcome to the next session, and we will take it further, okay, where we have completed the last session. So in the last session we have completed the topics relating to issue of share at discount and issue of share at premium. So what exactly we covered in the last session? Let's quickly revise. So we had discussed about difference between equity shares and preference shares. Then we talk about the share versus stock difference between, and then we started with issue of share at discount, then the share certificate and issue of share at discount and premium. So when I discuss about section 52, section 52 and 53 of the Companies Act. So 52 permits a company to issue shares at premium, and that premium has to be deposited in the separate bank account, and that is called as securities premium account. So that account, premium account, can be used for various purposes. So I had given you the list of purposes where you can use the premium. Then we talk about the section for 53, which says that a company cannot issue shares at discount. It means company cannot issue a share below the face value of the share. So company can issue the shares on par or above the face value, but company cannot issue below the face value. So there is only one exception where a company can proceed and issue the shares at discount. So what is that? So let's get started with the provision relating to the sweat equity shares, which are the provisions are given under section 54 of the Act. So except sweat equity shares, company cannot issue shares at discount. So let me just put over here sweat equity shares. So where the provisions are given under section 54. Okay. First, let's try to understand the definition of sweat equity share, which is defined under section 288, which says that it means such equity shares issued by a company to its directors or employees at a discount or for consideration other than cash for providing their know-how or making available rights in the nature of intellectual property rights or value additions. Okay, so this is the definition defined under section 288 subsection 88 of the Companies Act 2013. So what does it mean? So this definition says that it is nothing but a kind of equity shares. So it is a part of equity shares only issued by the company, but it is issued to its directors or employees at a discount, okay, or for consideration other than cash. Okay, so not necessary company should issue these particular shares, equity shares, to directors or employees uh, for cash only. It can be issued other than cash, but for what? For providing their know-how or making available rights in the nature of intellectual property rights or value addition. See, when the employees or the directors, they work for the company, they are putting their heart, okay, they are putting lot of efforts, and those efforts should be recognized by the company. So when any kind of employee who is providing some know-how or creating some intellectual property in the form of patents, you can say, then his efforts should be recognized, and those efforts can be recognized in the form of sweat equity shares. So he may be given some sweat equity shares. So this is a different category of shares altogether. It is a form of equity shares only, but he can be provided at discount just for providing that value addition to the company. So that it is a kind of retention policy, you can say, where the employees can be retained and they can become the owner, okay, to certain proportion in the shareholding. But while doing so, there are some provisions one needs to understand. So there are company share capital and debenture rules 2014. As per that, what is mean by employee? So employee means a permanent employee of the company who has been working in India or abroad India, first of all. Then director of a company, whether he can be whole-time director or not. So even the non-executive directors can also be recognized. Or an employee or a director as defined, okay, in subsection A or B above, that is the permanent employee or the director of a subsidiary company, whether it is situated in India or outside India. Okay, so even the subsidiary companies, employees and directors can also be recognized with the issuance of, okay, by issuing these sweat equity shares. And value additions, as I told you, it can be related to the creation of some kind of, you can say, intellectual property rights, okay, which will be beneficial for the company, by which a company is going to earn good amount of money. Now we need to understand, okay, the conditions about sweat equity shares. So basically this section 54 talks about conditions for issue of sweat equity shares. Conditions for issue of shares. Section 54. So section 54 permits issue of such equity shares to employees or directors in recognition of their contribution. Okay, so these are issued to the employees or director in recognition of their contribution for providing know-how, as we have already discussed. So basically, as a contribution made by them, okay, employees or directors, you can say, it can result into the increased profits in the company for the number of years, and that is the reason, just to, okay, give a kind of return in the form of recognition, these shares can be issued. Now what are the conditions? Okay, so section 54 1 says that it provides that notwithstanding anything contained in section 53. So section 53 talks about the issue of share at discount. A company can issue sweat equity shares of a class of shares already issued. So if the equity shares are already been issued, the same class of equity shares can be issued, but the conditions should be fulfilled. Which are those conditions? Let's try to talk about it. So the issue has been authorized by a special resolution passed by the company. Okay, so the special resolution in the general meeting should be passed. Following number of shares, current market price, consideration, of course if any, or employees to whom are to be issued if a company is listed company should comply with SEBI regulations, okay. So first these three points we will discuss. First of all, the company has to authorize this particular kind of issue of sweat equity shares by passing a kind of special resolution in the general meeting of the company. So shareholders meeting should be called for, and then so the special resolution has to be passed, and then company can proceed further, okay, to issue sweat equity shares. There are some details which should be mentioned properly. So which details should be mentioned? Number of shares, how many number of shares company is going to issue, current market price of that share. So it may so happen the current market price may be 100 rupees, but company is issuing at some discount. That is also possible. Consideration, if any, which company is going to consider, like it may be for the other than cash, as I told you. Then the report, the valuation report has to be obtained for that matter. Then the class or classes of directors or employees. Okay, कौन से directors को दिए जाएंगे, employees को दिए जाएंगे, क्यों दिए जाएंगे. So all these reasons why, okay, why this class of employees, okay, all this information should be provided to the shareholders so that shareholders can take the informed decision. okay, about the issuance of sweet equity shares. So if the company is listed, company will have to, okay, comply with the SEBI regulations relating to the issue of sweet equity shares. Now there is one more rule, okay, companies share capital and debenture rules. So where it talks about how the sweat equity shares can be issued. So these are the rules framed notified by the Ministry of Corporate Affairs. So as per that, the explanatory statement has to be affixed uh, to the special resolution, proposed special resolution. So it is important that information, all possible information should be provided to the shareholders, like the date of the board meeting at which the proposal was approved and it was recommended to the shareholders. The reasons or justification for the issue, what are the reasons and justification for the issue, the class of the shares under which the sweet equity are intended to be issued. All this information should be provided. Okay, the total number of shares to be issued, and the directors to whom or employees to whom the sweet equity is going to be given, and even the principal terms, if any, okay, should be provided. So company should provide all this information, possible information, to the shareholders, so that shareholders will be in a position to take the proper decision. Then sweet equity shares, the few important provisions we can again note down over here. There is a lock-in period. Okay, so sweet equity shares should be locked for 3 years. Okay, so sweet equity shares can be locked for 3 years from the date of allotment. So it is necessary that, okay, when you are issuing the shares to the uh, employees or directors, it should not happen that they have purchased at discount and immediately they will transfer it to outsider and they will earn the profit. It should not happen in that way, and that is the reason the law says that, okay, they have to keep the lock-in period of at least 3 years for the sweet equity shares. So it should be locked for 3 years from the date of allotment, and the period of expiry of the lock-in shall be stamped in the bold and or mentioned in any other prominent manner on the share certificate, so that it cannot be just transferred. Then valuation aspects, it should be issued, it should be valued at a price determined by the register valuer at a fair price, giving justification for such valuation. Okay, so sweet equity shares to be issued shall be valued at a price. Valued at a price determined as fair price. Okay, so he has to provide the justification why he has arrived at that particular fair price, and when the valuation of the IPR is to be made, okay, or intellectual property or right or any kind of know-how or value additions, okay, for which the sweet equity shares are going to be issued by the company, again shall be carried out by the register valuer only. So he should provide a kind of proper report, okay, while when the shares are issued for the non-cash. Then after issuance of the sweat equity shares, board's report should disclose the details of sweat equity shares. Okay, so board's report should disclose the details of sweat equity share. So board report should normally contains, it is a kind of report given by the board of directors to the shareholders of the company every year. So it should contain during the last preceding year, okay, how many shares have been issued to the as a sweat equity share to the shareholders. So everything should be properly maintained, and then maintenance of the register. Okay, so company shall maintain a register of sweat equity shares. Company will have to properly maintain the register for this particular purpose. So these are all provisions relating to the sweat equity shares. We can just write down: company should maintain register. Okay, company should maintain register. So these are all important points one should take into consideration in order to issue the sweat equity shares. Let me just highlight the important points. The fair price, maintain register. I hope you have understood the sweat equity shares. Please make a note of all these points. So definition, we started with the definition. Then conditions. So special resolution, some details should be provided in the explanatory statement form to the shareholders. It should comply with the SEBI regulation if the entity is listed on the stock exchange. It shall be valued at a fair price and disclose the details. Company should maintain the register. So this topic we have covered. Now let's move on to the next topic. The next topic will be transfer or transmission. Transfer or transmission of securities. Let's talk about this topic. Okay, so here we are going to talk about two different aspects: transfer or transmission of securities. One more very little term we will talk about, that is transposition of shares. Okay, first let's concentrate on transfer and transmission of securities. See, one of the very important feature of the company form of business is its transferability. So company shares are freely transferable, as what we have studied. So section 44 of the Companies Act says that the shares or debentures are considered as movable property is transferable in the manner as provided in the articles of association of the company. Whereas section 58, it talks about, okay, the securities or other interests of any member in the public limited company shall be freely transferable. So what does it mean? So section 44 says that, okay, it is a movable property and can be transferred in the manner as provided under articles of the company. So section 44 says that securities are movable property and can be transferred in the manner provided by articles of association of the company. Whereas section 58 says that securities of any member in a public company shall be freely transferable. So when transfer basically takes place between transferor and transferee, it is a kind of contractual relationship happens between transferor and transferee. So it talks about section 58 subsection 2 talks about that securities of the public limited company shall be freely transferable. Then what about the private limited company? As we have studied under section 2 subsection 68, okay, the securities of the private limited company, the transfer of securities in case of the private limited company can be restricted by its articles. So these three provisions are very important to understand. Section 268 talks about the definition. It gives the definition of the private limited company. So private limited company can restrict the right to transfer its shares by AOA. Okay, so through AOA, okay, this right is given to the private limited company. So private limited company may restrict to transfer the shares. Now let's talk about that. So private limited company, what kind of restriction can be laid down in case of the private limited company? So like when any kind of shareholder agreement happens between the transfer and between the shareholders, so there can be some rights which can be reserved. Like if shareholders would like to transfer the securities, they may only have to approach first to the existing shareholders, and if the existing shareholders refuse to accept that particular offer, then only shareholders can go to the outsider and transfer the securities. So it means that total ban cannot be possible, but yes, it can be restricted to some extent. But In case of the public limited company, so this right basically in case of the private companies, the restriction laid down can be laid down as per articles is known as right of preemption. Okay, so this right can be put in the articles of the association of the company. But in case of public limited company, as it can be transferred freely, so company shall be further, the board of directors of the company or the concerned depository has no discretion basically to refuse or withhold the transfer of any security. So the transfer has to be effected by the company or depository automatically, okay, and immediately, because the shares of the public limited company are held in the demat account. So it is always okay, the securities are freely transferable for that particular matter. Now we will talk about some aspects, okay, how the transfer takes place. So let's talk about the important points relating to the transfer of securities, transfer of shares. Okay, one by one we'll try to understand. First point should be a proper instrument of transfer, proper instrument of the transfer for transfer of securities held in physical form shall be in form number SH4. So this is the form number SH4. An instrument should be dated and executed by or on behalf of transferor and transferee. Transferor and transferee. An instrument should be duly stamped. An instrument should be duly stamped. an instrument of transfer should be delivered to the company by transferor or transferee within 60 days. Within 60 days from date of execution. Okay, from date of execution. Then the company has to deliver certificates first within 2 months in case of subscribers from date of incorporation in case of subscribers within 2 months in case of allotment within 1 month in case of transfer or transmission within 6 months in case of allotment of debentures in case of allotment of debentures. Okay, so these are some of the important points relating to the transfer of securities. So first of all, a proper instrument of transfer should be for the transfer of security should be there in the physical form, which shall be in the form number ASH4. So here we are talking about the physical share transfer. Okay, so if the shares are held in the demat account, then the Depositories Act will be applicable. But when the shares are in the physical format, then these provisions should be made applicable. So form number SH4 should be duly executed. It is a kind of instrument of transfer. The pro forma of the form should be as per prescribed for pro forma, which is given under the rules. Then that instrument should be properly dated. It should be properly dated and executed, signed by both transferor and transferee. So what types of details should be there? At which price the transfer is taking place, because the stamp duty will be based on the price of the shares. How many shares are going to be transferred from whom to whom. So it is a kind of agreement or contract, you can say, as the instrument of transfer is a kind of contract only between the transferor and transferee. It should be duly stamped. So normally government, the Indian Stamp Act will be made applicable 0.25 paisa per 100 rupees shares. Okay, is the stamp duty which is made applicable for transfer of securities. If it is a gift deed, if there is no consideration involved, then the market value of the shares should be taken into consideration, and the stamp duty will be levied on the market value of the shares. An instrument of transfer should be delivered. Okay, once this instrument of transfer is executed, it should be properly delivered to the company by transferor or transferee. Okay, within how many days? Within 60 days. Within 60 days. Okay, within 60 days from the date of execution. So this particular transfer deed, once it is executed, it should be taken in the, it should be given in the custody of the company. Then company will look into it. Company will then, after verifying scrutinization whether the transfer has taken place or not, then company will issue the share certificates. Now, along with this particular deed or transfer of instrument of transfer, the share certificates, the existing share certificates should be given to the company, so that company will make remarks of the transfer, as well as company will make the necessary corrections in the register of members as well. The company has to deliver certificates. So company, after getting the share certificate, it is the duty of the company to deliver the certificate. So there are 4 different cases. Within 2 months from the date of incorporation in case of the subscriber. So if it is a newly incorporated a company and the subscribers are there, then from the date of subscriber within 2 months the share certificate should be delivered. The certificates should be delivered. Within 2 months in case of allotment. Okay, if it is a new allotment, if it is a issue of shares are there, okay, then allotment will be made, the new allotment will be made, then the 2 months. If it is transfer or transmission, so we are here talking about transfer of shares. So if it happens the transfer or transmission, then it is within 1 month. Transmission is basically when the shares of the deceased person will be transferred in the name of the legal representative. If it is allotment of the debentures, within 6 months that allotment can be made. Now these are basically the provisions given in the Companies Act, and the penalty is also given. The company shall be punishable with fine which shall not be less than 25,000 but which may extend to 5 lakhs, and every officer who is in default shall be punishable with fine which shall not be less than 10,000 rupees which may extend to 1 lakh rupees, and that is the reason the transfer of security should be made properly. Okay, so penalty is also given. Penalty so section 50.6.6 talks about the penalty. So let's talk about the penalty directly. There are 2 types of penalties. one is about the company, and so if the company is there, okay, or every officer. So company fine rupees 25,000 to rupees 5 lakhs, fine rupees 10,000 to 1 lakh, 10,000 to 1 lakh. Okay, so this will be the penalty. Now let's talk about transmission. Transmission of securities. So basically it refers to those cases, where a person acquires an interest in property by operation of law. By operation of law. For example, right of inheritance or succession. Or insolvency. So transferation of securities takes place when the registered holder of the security, maybe he may die, or he may be adjudicated as insolvent. Then it goes into liquidation in case of adjudication. So, and because of that, deceased person cannot now own anything. The ownership of all the property passes after his death to his legal representative. So that procedure is called as transmission of securities. So it may take place. So this is a kind of definition. One, we need to understand the difference between transfer and transmission, which may be asked in exam. So we'll try to understand directly the difference between transfer and transmission. Let me just correctly put this particular divide. Oh, it is not happening. Yes. So first we are talking about transfer of securities, and then transmission of securities. So basically it takes place by, you can say, voluntary act of parties. Here it is a result of the operation of law. Okay, it is a result of the operation of law, what we have discussed. An instrument of transfer is required. An instrument of transfer is required. But here, is there any instrument required? No. No instrument of transfer is required. Okay. So as we already studied, you require the form SH4, but here there is no such procedure. Okay. Transfer is normal course of transferring property transmission takes place on death or insolvency, that we have already studied. So it is a normal way of transferring, but it takes place on death or insolvency. So it is generally made for some consideration. It is not always free of cost like a gift. It generally made for some consideration amount should be involved. But is there any consideration amount? No, it is not required. So you can say it is made without consideration. Is made without consideration. So here we are talking about transfer, and here we are talking about transmission. So fifth point, where do we require the stamp duty? Yes. Stamp duty is payable on transfer. But here there is no stamp duty. No stamp duty is payable on transmission. as soon as transfer is complete, the liability of transferor ceases. But what about here? The liability does not cease because shares may be just transferred to the transmitted to the legal heir. Continue to be subject to the original liabilities. Okay, so these are the different points, differences between transfer and transmission. So let's quickly do it. So it's a voluntary act, it is by operation of law. An instrument is required, no instrument is required. It's a normal course of transferring, it takes place on death or insolvency. Some consideration, without consideration. Stamp duty, no stamp duty. So liability ceases. Okay, so liabilities are always there. So we have completed transfer and transmission over here. So transmission. So from here we have discussed. If you want to write down, please write it down. These are the important points. Transmission, this is a kind of definition. Operation of law. And then we discuss the transfer versus transmission. Now we'll talk about the last topic, a very simple topic, that is transposition. Transposition of name. Okay, so this is just a kind of procedure, no particular provision is there. So basically what happens when there is a kind of rearrangement of the names, so in case of joint shareholders, you can say, in case of joint shareholders, transposition of name is a process to alter, you can say, or rearrange, alter or rearrange the serial order of names of shareholders, I would say joint shareholders, in register of members. So this is a normal process where a company, in case of the joint shareholder company, if there is a request from the joint shareholder, let's assume that A and B, okay, this is the name, okay, which is mentioned in the joint shareholder. After transposition it may be B and A, like that, okay. So the first name, if B wants to, if these two shareholders are ready, okay, so they can give the application to the company and they can ask to rearrange the names, okay, in the share certificates, on the share certificate as well as in the register of member. So board approval is sufficient for that matter. Application has to be obtained, is to be given to the company, and this transposition of name can be done. So it is just a concept, okay, which one should understand the difference between transfer, transmission and transposition of name. I hope today you have understood all the provisions which we have talked about. We have started with sweet equity shares, then we completed transfer of share securities, transmission of securities, and transposition of name. So please do watch this video, read the notes carefully. Okay, we'll come up with a new topic in the next session. Till then, goodbye.